American Politics Today by Bianco and Canon, Norton Loose, the 7th Essential Edition. Chapter 4, Part 1, Civil Liberties. It's a free country, right? Under the guise of speech codes and safe places and trigger warnings, these universities have tried to restrict free thought, impose total conformity, and shut down the voices of great young Americans. All of that changes starting right now. President Donald Trump. Quote, if I were president of a university and I had some hate speech person coming, I wouldn't let them come in. I just wouldn't. John Kish, former Ohio government. The constitutional protection for speech is clear and strong. Congress shall make no law abridging the freedom of speech. However, recent protests against the controversial speakers booked to speak on college campuses are calling into question the scope of those protections. Must college campuses allow talks by right-wing provocateur Milo Yiannopoulos, who has said child sex abuse really is not that big of a deal, or white nationalist Richard Spencer, who has called for White House ethno-state? Must they embrace conservative speakers like political commentator Ann Coulter and economist Charles Murray? All of these speakers met strong and sometimes violent protest at campuses around the country. A CNN headline described the situation as war on campus. A speech by Richard Spencer at the University of Florida caused Governor Rick Scott to declare a state of emergency, and the university had to spend nearly $600,000 to provide security for the event. Despite these efforts, 3 men shouting, "Heil Hitler, Heil Hitler," fired a shot at students demonstrating against Spencer's speech, but nobody was hurt. Many are calling for limits on the kind of hate speech that some claim speakers like Yiannopoulos and Spencer promote, and for the creation of safe places on campus where students would be protected from hurtful speech within a broader effort to promote social justice. Others see such efforts as political correctness run amok and are concerned that free speech is under attack as conservative speakers are prevented from talking. When announcing his executive order on free speech on campus, President Trump said, "We will not stand idly by and allow public institutions to violate their students' constitutional rights. If a college or university doesn't allow you to speak, we will not give them money." Sorry about that. Let's do the next page. The controversy over free speech on campus does not divide neatly along partisan or ideological lines. While strong disagreeing with the conservative speaker's views, recently President Obama has expressed support for the free speech side, saying college students shouldn't be coddled and protected from different points of view. Feel free to disagree with somebody but don't try to shut them out. The left-leaning American Civil Liberties Union has also defended free speech on campus, arguing speech that deeply offends our morality or is hostile to our way of life warrants the same constitutional protection as other speech, because the right of free speech is indivisible. When we grant the government the power to suppress controversial ideas, we are all subject to censorship by the state. Some have argued that the controversy is overblown, pointing to evidence that there is more support for the First Amendment on college campuses than in the public at large, and that the number of disinvited conservative speakers is down from a high of 24 in 2016 to 5 in 2019. However, others argue that the swastikas and nooses, historically symbols of hate and aggression that have recently been portrayed on campuses, are not free speech, and that the real question is where to draw the line. Defining the boundaries of our liberties and freedoms, like freedom of speech, is messy and complicated. Can controversial speech on college campuses be limited? When we say America is a free country, what does this really mean? Are there limits to those freedoms? If so, how should political actors draw the lines between protected behavior and actions that may be regulated? Defining civil liberties. The terms civil rights and civil liberties are often used interchangeably, but there are some important differences. See Nuts and Bolts 4.1. To oversimplify a bit, civil liberties are about freedom and civil rights are about equality. For more on this distinction, see Chapter 5. Civil liberties are deeply rooted in our key idea that politics is conflictual and that it involves trade-offs. When the Supreme Court rules on civil liberties cases, it must balance an individual's freedom with the government's interest and the public good. For example, in the war on terrorism, the government must balance civil liberties with the national security. Many Americans have been concerned that government surveillance invades people's privacy and that the treatment of suspected terrorists violates due process rights. At the same time, most Americans would probably agree that in some instances, these measures might be warranted. For example, if a nuclear device were set to detonate in Manhattan in 3 hours, few would insist on protecting the civil liberties of someone who knew where the bomb was hidden. Once we recognize that our freedoms are not absolute, it becomes a question of how they are balanced against other interests such as national security, public safety, and public health. Along with balancing competing interests, court rulings must also draw the lines to define the limits of permissible conduct by the government or by an individual in the context of a specific civil liberty. For example, despite the First Amendment's protection of freedom of speech, it is obvious that some speech absolutely cannot be permitted. The classic example is falsely yelling fire in a crowded theater. Therefore, the courts must interpret the law to draw the line between protected speech and impermissible speech. The same challenge applies to other civil liberties such as the establishment of religion, freedom of the press, freedom from illegal searches, or other due process rights. See how it works, the First Amendment. Courts define the boundaries of civil liberties, but the other branches of government and the public often get involved as well. The earliest debates during the American founding illustrate the broad public involvement concerning the basic questions of how our civil liberties would be defined. Should government be limited and explicit statement of individual liberties? Would these limitations apply to the state governments or just the national government? How should these freedoms evolve as our society changes? As we will see in this section, interpretations of these constitutional protections have changed over time. Origins of the Bill of Rights. Originally, the Constitution provided very limited protection of civil liberties. It guaranteed habeas corpus rights, a protection against illegal incarceration, and prohibited bills of attainder, legislation, punishment someone for a crime without the benefit of a trial, and ex post facto laws that are retroactively change the legal consequences of some behavior. Delegates to the Constitutional Convention made a few attempts to include a broader statement of civil liberties, including one proposed by George Mason and Eldridge Gerry 5 days before the convention adjourned. But their motion to appoint a committee to draft a Bill of Rights was rejected. Charles Pinckney and Gerry also tried to add a provision protecting the freedom of the press, but that too was rejected. Mason and Gerry opposed ratification of the Constitution partly because it did not include a Bill of Rights, and many anti-federalists echoed this view, including, feel free to pause, influential Brutus essays, which were written to encourage New Yorkers to reject the Constitution. See especially Brutus 1. Some states ratified the Constitution but urged Congress to draft specific protections for individuals and states' rights from federal action. They believed that the protection of civil liberties from state action should reside in state constitutions in other states. The anti-federalists who lost the ratification battle continued making their case to the public and Congress. Madison and other supporters of the Constitution agreed that the first Congress would take up the issue, despite the reservations that a Bill of Rights could lead the people into falsely believing that it was an exhaustive list of all their rights. State conventions submitted 124 amendments for consideration. The list was whittled down to 17 by the House and then to 12 by the Senate. This even dozen was approved by the House and sent to the states, which in 1791 ratified the 10 amendments that became the Bill of Rights. See Nuts and Bolts 4.2. I will zoom in so that you may pause this. Despite the document's profound significance, one point limited its reach. It applied only to the laws and actions of the national government and not to choose of the states. This decision proved consequential because the national government was quite weak for the first half of our nation's history, because states exercised at least as much power over people's lives as the national government did. It would have been more important for the Bill of Rights to limit the states than to limit the federal government. The Supreme Court used the Bill of Rights only once before 1866 to invalidate a federal action in the infamous Dred Scott case that contributed to the Civil War. See Chapter 3, Selective Incorporation and the 14th Amendment. The significance of the Bill of Rights increased somewhat with the ratification of the 14th Amendment in 1868. It was one of the 3 Civil War amendments that attempted to guarantee the newly freed, formerly enslaved people equal rights as citizens of the United States. The other 2 Civil War amendments were the 13th, which abolished slavery, and the 15th, which gave formerly enslaved men the right to vote. Northern politicians were concerned that Southerners would deny basic rights to the formerly enslaved people, so the sweeping language of the 14th Amendment was adopted. Section 1 of the 14th Amendment says, "All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immune of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction to equal protection of the laws." This language sought to ensure that states would not deny newly freed people the full protection of the law. The Due Process Clause, which forbids any state from denying life, liberty, or property without due process of law, led to an especially important expansion of civil liberties, because the Supreme Court had previously interpreted a similar clause in the Fifth Amendment to apply only to the federal government, despite amendment's clear statement that no state shall make or enforce any law. In the Supreme Court's first opportunity to interpret the 14th Amendment in 1873, it continued to rule in favor of protecting states from national government actions, only embracing the dual citizenship idea set forth in the Barron versus Baltimore. Over the next 50 years, a few justices tried mightily to interpret the 14th Amendment to protect civil liberties against state government action, culminating in the 1925 case Gitlow versus New York. Here the court said for the first time that the 14th Amendment incorporated one of the amendments in the Bill of Rights and applied it to the states. The case involved Benjamin Gitlow, a radical socialist convicted under New York's Criminal Anarchy Act of 1902 for advocating the overthrow of the government. The court upheld his conviction, arguing that his writings were the language of direct incitement, but it also warned state governments that there were limits on such suppression of speech. Over the ensuing decades, most civil liberties covered in the Bill of Rights were applied to the states on a right-by-right, case-by-case basis through the 14th Amendment. However, the process of selective incorporation was not smooth and incremental. Rather, it progressed in surges with flurries of activity in the 1930s and the 1960s. See Table 4.1. As a result of the Bill of Rights has evolved from a narrow range of protections for people from national government actions during the early 19th century to a robust set of protections for freedom and liberty that limit national, state, and local government actions today. Feel free to pause for 4.1 if you can read it. I can try and zoom in. Freedom of religion. The First Amendment has two parts that deal with religion. The Establishment Clause, which has been interpreted by to mean that Congress cannot sponsor or endorse any particular religion, and the Free Exercise Clause, which has been interpreted to mean that Congress cannot interfere in the practice of religion unless there are important secular reasons for doing so. Essentially, the former says that Congress should not help religion, and the latter that it should not hurt religion. The Establishment Clause is primarily concerned with drawing lines. For example, does a prayer at high school football games or a nativity scene on government property constitute state sponsorship of religion? The Free Exercise Clause has more to do with balancing interests such as balancing public safety, concerning against snake handling in religious services, and the use of Amish buggies on public highways. The combination of the Establishment and Free Exercise clauses result in a general policy of non-interference and government neutrality toward religion. As Thomas Jefferson said in 1802, the First Amendment provides a wall of eternal separation between church and state. This language continues to be cited in court cases in which religion and politics intersect. Since both areas carry great moral weight and emotional charge, the boundaries of religious expression remain difficult to draw. The Establishment Clause and separation of church and state. Determining the boundaries between church and state, the central issue of the Establishment Clause, is very difficult. We know that the founders did not want an official state religion and did not want the government to favor one religion over another. But beyond that, it's hard to say. Jefferson's wall of eternal separation has been cited in court decision that prohibits state aid for religious activities. But lately the court has been displaying a more accommodationist perspective that sometimes allows religious activity in public institution. Public prayer. The issue of prohibition of prayer in public schools exploded onto the political scene in 1962 when the court ruled in Engel versus Vitale that a prayer written by the New York State Board of Regents and read every day in the public schools violated the Establishment Clause and the separation of church and state. Banning the prayer caused public outcry protesting the perceived attack on a religion. Over the next 50 years, Congress repeatedly tried unsuccessfully to amend the Constitution to allow school prayer. Meanwhile, the court continued to take hard line on school-sponsored prayer. In 1985, the court struck down the practices of observing a one-minute moment of silence for meditation or voluntary prayer in the Alabama public schools, showing that isn't the words of the prayer that are the problem, but the idea of prayer itself. More recently, the court said that benedictions or prayers at public school graduations and a school policy that allowed an elected student representative to lead a prayer at a high school football game also violated the Establishment Clause. The former established a strong coercion test that prohibited prayers that may appear to be voluntary. Students are not required to attend their high school graduation, but in effect are compulsory. Yet the court has upheld the practice of opening every session of Congress with a prayer, has let stand without comment a lower court ruling that allowed a prayer that was planned and led by students rather than recited as school policy. At a high school graduation and in 2014 upheld prayers by voluntary chaplains for town board meetings in Greece, New York. The latter case was especially significant because the legislative prayers were offered at town meetings that included residents, unlike the previously approved prayers that were intended for the elected leaders only. Aid to religious organizations and religious symbols. The court had even had an even more difficult time determining principles to govern government aid to religious organizations, either directly through tax dollars or indirectly through the use of public space for religious symbols. One early attempt was known as the lemon test. After one of the parties in a 1971 case involving government support for religious schools, Lemon versus Kutzman, here the justices ruled that a practice violated the Establishment Clause if it, 1, did not have a secular legislative purpose, 2, either advanced or inhibited religion, or 3, fostered an excessive government entanglement with religion. The third part of the test was later found open to interpretation by lower courts and therefore led to conflicting rulings. The court started to move away from the Lemon test in a 1984 case involving a city-owned crochet that was displayed in a park owned by a nonprofit organization or corporation. The court allowed the nativity display, saying the Constitution does not require complete separation of church and state. It affirmatively mandates accommodations, not merely tolerance of all religious, and forbids hostility toward any. This endorsement test, unquote, simply says that government action is unconstitutional. If a reasonable observer would think that the action either endorses or disapproves of religion, later rulings would think that the action either endorses or disapproves of religion. Later rulings upheld similar religious displays, especially if they confirmed what observers have labeled the, quote, 3 plastic animals rule, quote, unquote. If the baby Jesus is surrounded by Rudolph the Red-Nosed Reindeer and other secular symbols, the overall display is considered sufficiently non-religious to pass constitutional muster. More recently, in a 2019 case, the court upheld the American Legion's right to display a 40-foot cross at a World War I memorial on state property in Bladensburg, Maryland, saying that lemon should not apply in cases that involve the use for ceremonial, celebratory, or commemorative purposes of words or symbols with religious associations. Instead, the court ruled the cross is undoubtedly a Christian symbol, but that fact should not blind us to everything else that the Bladensburg cross has come to represent. Destroying or defacing the cross that has stood undisturbed for nearly a century would not be neutral and would not further the ideals of respect and tolerance embodied in the First Amendment. 3 justices wanted completely overturn lemon. Justice Garouche called it a dog's breakfast, a confusing mess, but it still has application to direct government support for religious schools. In cases involving funding for religious schools, the court has applied the accommodationist perspective by looking more favorably on providing tax dollars to student families to subsidize tuition costs at religious schools than on funding parochial schools directly. In 2011, the court expanded taxpayer support for religious education when it upheld an Arizona law that provided state tax credits for contributions to organizations that provided tuition for religious schools. The court has also ruled that it is acceptable
to use federal funds to buy computers and other educational equipment to be used in public and private schools for secular, neutral, and non-ideological programs, and tax dollars for a sign language interpreter for deaf student who attended a parochial school. In a landmark 2020 decision, Espinoza versus Montana Department of Revenue, the Supreme Court ruled that 5-4 that under the Free Exercise Clause, a state could not prevent the use of state-based publicly funded scholarship funds meant for private school tuition from being applied toward religious school tuition. The case was brought by Montana parents who qualified for these income-based scholarships and whose children attended a Christian school. They were informed that the scholarship funds could not be applied toward the religious school tuition because of the Montana state rule barring the use of, quote, any direct or indirect appropriations or payments, unquote, to any religious organizations or schools affiliated with religious organizations. The case went to the Montana Supreme Court, which in 2018 found the entire scholarship program unconstitutional as it unfairly benefited religious schools. As a result, the public scholarship program was terminated. So the parents appealed to this U.S. Supreme Court in the majority opinion. Chief Justice Roberts wrote that the program violated the Free Exercise Clause as it bars religious schools from public benefits solely because of the religious character of the schools, and also bars parents who wish to send their children to a religious school from those same benefits, again solely because of the religious character of the school. The Free Exercise Clause. While the freedom of belief is absolute, freedom of religious conduct cannot be unrestricted. That is, you can believe whatever you want without government interference. But if you act on those beliefs, the government may regulate your behavior. And while the government has restricted religious conduct in dozens of cases, the freedom of religion has been among the most consistently protected civil liberties. Hundreds of cases have come before the court in the area of free exercise of religion. Here are some examples of the questions they addressed. May Amish parents be forced to send their children to schools beyond the 8th grade? No. As established in Wisconsin versus Yoder in 1972, is animal sacrifice as part of a religious ceremony protected by the First Amendment? Generally, yes. May Mormons have multiple wives? No. Does the First Amendment protect distribution of religious leaflets on public streets and religious public meetings in public parks? Yes, for both, but the latter is subject to, quote, time, manner, and place, unquote, restrictions. May people be forced to work on Friday night and Saturday if those are the days of their worship? No. May religious dress be regulated? Generally not, but in some contexts, such as military, yes. Keep in mind that this list is not exhaustive. On one particular case brought by plaintiffs who had been fired for using peyote as part of a religious ceremony and then denied unemployment benefits because they had broken the law, had broad implications that define the general basis for government restrictions of religious expression. The court ultimately ruled that the state of Oregon had not violated the Free Exercise Clause in denying the plaintiffs unemployment benefits. More significantly, with this ruling, the court announced a new interpretation of the Free Exercise Clause. The government does not need a compelling interest in regulating a particular behavior to justify a law that limits a religious practice. It only needs a demonstration that the law in question was a, quote, neutral law of general applicability, unquote. In other words, after this decision, it would be easier for the government to limit the exercise of religion because the court would no longer require a compelling reason for the restrictions. Congress responded by passing the Religious Freedom Restoration Act, the RFRA, in 1993, reinstating the need to demonstrate a compelling state interest before limiting religious freedoms. After several cases and congressional actions, the court made it clear that it would have the final word in deciding when a compelling interest is required in order to limit religious practice. The court relied on this standard in the controversial 2014 case involving the family-owned Hobby Lobby stores, ruling that a, quote, closely held, unquote, private corporation could not be forced to provide contraception to women under the Affordable Care Act if there was a, quote, less restrictive, unquote, means available to have the insurance provided. This was the first time that a corporation was given First Amendment protections based on the religious beliefs of the owners of the corporation. In 2020, the court extended the opt-out options to private employers on religious or moral grounds. The court also expanded religious freedom when it approved, for the first time in 2017, direct government payments to a church in support of secular purposes, in the case funds for a playground in a church-run daycare center. The court ruled that churches should have equal access to such grants made available to fund secular programs. In a highly anticipated case, the court was faced with a difficult question concerning the civil rights of a same-sex couple and the religious beliefs of a cake shop owner. The baker had refused to bake a cake for the couple, saying that doing so would violate his religious beliefs. The court avoided the ruling on this central question because the Colorado Civil Rights Commission, which initially heard the case, did not treat religion in a neutral manner and did not give the baker a fair hearing. While concluding that the baker did not have to bake the cake because of the commission's biased behavior, the court affirmed that the Free Exercise Clause will not provide a basis for such refusals of service. When there is not the expression of hostility to religion and the LGBTQ, people have the right to, quote, equal access to goods and services under a neutral and generally applicable public accommodations law, unquote. This is the end of Chapter 4, Part 1.